Imagine this. A woman files for survival maintenance in 2002. The court. It finally rules in 2011. That's a devastating 9-year wait.
Yeah.
And today we're diving into the core legal question that went all the way to the Supreme Court. Does that maintenance payment start from 2011, the date of order, or does it go all the way back to 2002, the date of application?
In this whole deep dive, it's really about the battle against judicial inertia. It's what the system calls the culture of adjournments.
Okay, what does that mean exactly?
Well, the context here is Section 125 of the Code of Criminal Procedure. And this isn't just standard law. It's what's called social legislation.
Right.
Its entire purpose is preventative. It's designed to fight, vagrancy and destitution. So when the system slows down on something like this, it basically defeats the whole point of the law, which is immediate survival.
Okay, so let's unpack this by looking at the landmark Supreme Court judgment. It's Bhuwan Mohan Singh v. Meena. And the facts of this case, they just lay bare a really painful systemic failure. Meena filed for 6,000 rupees a month in the family court, Jaipur, back in August 2002.
And Section 125 is supposed to be a summary proceeding.
Meaning it should be fast, right?
It's designed to be a quick, fast-track trial. And yet, this case dragged on and on until 2011.
So what happened when the order finally came?
Well, that's where the family court made this massive error. They issued the maintenance order, but ordered payment only from the date of that order, from 2011.
Wow.
Completely ignoring those 9 years, the wife was left with nothing.
So she appealed.
Of course. And the High Court corrected it. They granted payment from 2002, which resulted in a huge amount of arrears.
Back payments.
Exactly. And that's when the husband appealed to the Supreme Court.
Okay, but wait. The husband's argument was that the wife contributed to the delay. Isn't that a valid point in court? Why should he pay for 9 years of legal fighting?
And that is the absolute core conflict the Supreme Court had to resolve. They had to decide if, procedural technicalities could trump the social purpose of the law.
So could they?
Well, before this ruling, courts often required you to prove special reasons to get that backdated maintenance. It was a huge hurdle. But the Supreme Court, they just rejected that entire premise forcefully.
And this is where the ruling gets explosive. Justice Dipak Misra delivered a judgment that was basically a direct, scorching scolding of this whole system of delay.
It was.
He said the husband has a sacrosanct duty to provide support, and that the wife cannot, under any circumstances, be penalized financially for delays that the system itself creates.
The language was, it was revolutionary for procedural ruling. Justice Misra stated that procrastination is the greatest assassin of the list.
The killer of the legal dispute itself.
Exactly. And he noted that family courts often kept the windows of wisdom closed. He connected that institutional delay directly to the human cost. He called it emotional fracture and emotional fragmentation.
So what's the bigger picture here?
The bigger picture is that this ruling changed the whole incentive. Judges are now highly discouraged from delaying because that financial burden, all those arrears, will still fall to the husband to pay from the very first day.
So the final verdict was firm. The Supreme Court dismissed the husband's appeal. They cemented the rule. Maintenance must be awarded from the date of application, 2002.
They did allow the husband to pay those arrears in installments over 3 years, though. So, balancing justice with what's actually feasible.
Which brings us to the takeaways for you listening.
Right. For the public, this is critical. If your maintenance case drags on, even for years, you are legally entitled to claim that money from the day you filed. And you can cite this precedent, Bhuwan Mohan Singh, to reinforce that right.
And what about for the legal professionals listening?
For them, this is the pivot point. The court clarified you no longer need to prove special reasons to get backdated maintenance. The delay itself and the need to prevent vagrancy is justification enough.
So what does this all really mean then? This judgment is this powerful mechanism. It ensures that even if the judicial system moves slowly, the wait itself can't become a financial punishment for the person just trying to survive.
Which, raises an important question to think about. Given this binding precedent, what administrative or resource changes are actually needed to make sure family courts can deliver the speedy remedy Section 125 promises in the first place? Rather than just forcing judges to clean up the mess years later, that's something worth thinking about.